Buckle up, guys. Today we're diving into a classic sovereign citizen meltdown right from the opening seconds. The setup sounds routine. Court in session, names called, but you can already sense what's coming. The defendant hasn't even spoken yet, and the tone is already tense. These cases always start normal, then spiral fast. You've got a judge expecting order and a defendant preparing to flip the script entirely. That contrast is where the chaos begins, and trust me, it escalates quickly from here.
Reagan Evans presiding. While court's in session, there's no reading, walking, talking, driving, eating, smoking. When your name is called, please give your full and undivided attention to the court. Good morning, Your Honor.
All right, good morning. This is the People versus Carlos Durham. Ticket number 20397-842. Count 1, drove by license, not valid, or improper license. Ticket number SP1154063. Count 1, drove by license, not valid, or improper license. And it looks like we're here for a review on ticket number U40128517. The conviction is disorderly conduct. Good morning. Please say your name to the record.
I'm here, Your Honor. My name is Carlos. My name is Carlos of the Durham family, and I'm here as executor of the estate named in this matter.
All right, guys, here's where things start slipping off the rails. The defendant introduces himself not as a person in court, but as some abstract executor and beneficiary. That's a red flag straight out of sovereign citizen playbooks. Instead of addressing charges, he's trying to redefine reality itself. Courts deal in facts and law, not self-invented identities. The judge is grounded. The defendant is playing word games. And when those two worlds collide, it never ends well for the person trying to outsmart the system.
You can't appoint me as a trustee. I'm not the trustee on this matter. I'm the judge of this matter. And we're not dealing with any beneficiaries or any of that. You're dealing with a defendant. And it's my understanding that you are Carlos Durham and you're the defendant in this matter.
Do I have a right to subrogation? Does the prosecutor give me the right to subrogation? Do I have a right to subrogation?
I don't even know what that is. What's subrogation?
I require subrogation.
What is that?
You don't know what subrogation is, Your Honor?
I don't.
Now we see the first real clash. The defendant tries to assign authority to the judge in a completely nonsensical way, appointing her as a trustee to dismiss the case. That's not how any legal system works. You don't walk into court and rewrite roles like it's improv theater. The judge immediately shuts it down, bringing things back to reality. This is the moment where you realize he's not here to defend himself. He's here to perform a script that has failed countless times before.
Your bond and oath of office valid, current, up to date, and still in effect?
I'm an active member of the bar.
For the record, please present your bond and oath of office to the court. Is the prosecution bonded for this matter?
The prosecutor is not present right now, Mr. Durham, but I don't have to do that. So I'm here at special appearance, and I'm here for the purposes of demurrer. All rights reserved under my full God-given name, Carlos Lorenzo Durham, as indicated by this birth certificate. Mr.
Right
Durham,
here.
Mr. Durham,
I am also the sole beneficiary.
Things get more technical, or at least he tries to make them sound that way. He throws out subrogation, hoping big words will create confusion or authority. But context matters, and here it's completely misplaced. Legal terms aren't magic spells. They only work when applied correctly. The judge's confusion says everything. He's not arguing law. He's reciting fragments of it. And when you misuse terminology this badly, it doesn't strengthen your case. It exposes it.
Everything that you're stating does not apply to this court, sir.
So the Supreme Court and the Constitution doesn't apply to this court? What jurisdiction is this court operating under? Common law or admiralty jurisdiction?
All right. Now he doubles down demanding validation of the judge's authority, bond, oath, credentials. This is a common tactic. Challenge legitimacy instead of addressing charges. But courts don't pause proceedings to satisfy random demands. Authority isn't something you request proof of mid-hearing like a receipt. The judge stays composed, which is key here. She doesn't engage with the nonsense, because engaging gives it weight. And that's exactly what he's fishing for.
Jurisdictions that's mentioned in the Constitution. Which jurisdiction is this court operating under?
Neither. We're operating under state law. And the
so
law
it's operating under statutory? Is it operating under statutory jurisdiction, Judge? Because if it is, I need to know the rules and procedures for statutory so I can defend myself. Could you tell me where I can find a copy of that?
Mr. Durham, we're operating under the law of the city. These are city ordinances, and these are misdemeanors.
Those are not laws, ma'am. I'm American State National, ma'am.
Mr. Durham, these are your options today. This is, one is already set for a review because it looks like you already made admissions. It looks like you pled guilty to one charge.
I didn't plead guilty to nothing. I didn't plead guilty to nothing, ma'am. I didn't plead guilty to nothing, ma'am. A judge was operating.
Mr. Durham.
I didn't plead guilty to nothing, ma'am.
Now he claims special appearance and starts layering more jargon. Demur, beneficiary, legal entity. It's a verbal smokescreen. The goal isn't clarity, it's confusion. But the judge isn't buying any of it. Sovereign citizen arguments rely on the idea that if you sound complex enough, you can override reality. But courts operate on established law, not creative reinterpretation. At this point, it's clear he's not adapting. He's committed to a script that's already failing in real time.
You need to be respectful and let me say what I need to say. I've let you say what you needed to say. So you need to let the court speak now. So you've already pled guilty, sir, in 2017. Or no, your plea date actually was October 4th, it looks like. And you were charged with offer to engage the services of another for an act of prostitution. It was amended to disorderly conduct. And so we're here for a review on that matter.
Here comes the jurisdiction argument, arguably the most common move in this playbook. He questions whether the court has authority, tossing around common law and admiralty. It sounds dramatic, but it's disconnected from the actual situation. Traffic violations in a city. Jurisdiction here is straightforward. The judge doesn't need to prove it like a debate opponent. This isn't a philosophy class. It's a legal proceeding grounded in location and law. His argument collapses under its own irrelevance.
On proper license, the offense date is October 18, 2020. And then there's another drove while license not valid on proper license charge with the offense date of January 14, 2021. Now, today, you can either set these for, they're already set for a pretrial. So you can set this for a trial, which it could be a bench trial, where the court, meaning the judge, myself, would decide if you're guilty or not of these offenses, or you can set it for a jury trial. Those are your options, sir.
So my option today is not to challenge jurisdiction, because when jurisdiction is challenged, everything must stop and jurisdiction must be presented. You must prove your jurisdiction. And I'm challenging it right now. Everything must stop and you must prove your jurisdiction right now.
Now the judge brings receipts, previous plea, past charges, and suddenly the narrative shifts. He's not just arguing theory. He has a documented history contradicting his claims. His denial doesn't align with the record, and that's a critical mistake. Courts rely on documented facts, not verbal denial. This moment exposes the gap between his version of reality and the actual legal record. And once that gap is visible, everything he says afterward loses credibility.
I'm incorrect. Your oath of office says you're supposed to uphold the Constitution and all laws pursuant. The Constitution says I have rights, and you're not giving me, you're violating my rights by not telling me what jurisdiction we're operating under. Prove your jurisdiction, ma'am.
I'm not violating your rights, Mr. Durham.
Prove your jurisdiction, ma'am.
I don't have to prove my jurisdiction.
So yes, you do, because jurisdiction, when it has to be proven, must be proven. If you're exerting authority over me, you must prove your authority. Prove your jurisdiction, ma'am.
Mr. Durham, what we'll do what we'll do is we'll set this for a jury trial. And so
I want a jury of my peers. I'm an American state national, so I get 6 American state nationals as my jury.
The judge lays out clear options: bench trial or jury trial. Simple, direct, procedural. But instead of choosing, he pivots back to jurisdiction challenges. This is avoidance, plain and simple. When faced with real decisions, he retreats into abstract arguments. It's a pattern. Whenever accountability approaches, he changes the subject. But the court keeps moving forward because proceedings don't pause for philosophical detours. Eventually, reality forces a decision whether he likes it or not.
I need your oath of office and your bonding information so I can make sure you are who you say you are and who you claim to be and what your duties and responsibilities are. All public officials must be bonded. I need all of y'all for full disclosure. Am I getting full disclosure right now, ma'am? I need full disclosure before I can make any decisions.
I've told you all that. So
no, you did not tell me all that. I need the name and the address of your bonding company and your policy number to make sure your oath of office is current. I need all of that.
That doesn't apply here, Mr. Durham.
Really now? The law doesn't apply to you. You're above the law is what you're saying.
So I'm going to set this for a jury trial, sir. What I'll do is, do you want to retain your own attorney or are you going to represent yourself?
Ma'am, I'm only here for the one purpose of subrogation. Nobody has given me nothing what I asked for, but you keep trying to force yourself on me.
Now the confrontation intensifies. He insists everything must stop until jurisdiction is proven. But that's not how legal systems function. You don't halt proceedings based on personal demands. The judge remains firm, not escalating, just continuing. That calm control is key. It keeps the courtroom grounded while he spirals. This contrast highlights the core issue. One side operates within structure. The other tries to dismantle it without understanding it.
It doesn't apply to this court, Mr. Durham. If you're here for
so why don't you dismiss the case? Because I was not driving, I was traveling, ma'am.
Mr. Durham, you are here as a defendant. You're not here as a
No, I'm not here as a defendant, ma'am.
Beneficiary.
I'm here as a beneficiary, ma'am.
You cannot come here and tell me how it's going to work. That is not how it goes.
So I need full disclosure. Am I getting full disclosure?
Absolutely.
Yes or no?
Yes.
What jurisdiction is this court operating under? Common law or admiralty jurisdiction? Which jurisdiction is this court operating under? Statutory jurisdiction?
The jurisdiction of the city of Detroit.
Is that statutory? Is that statutory? Because the city of Detroit don't get to overrule the Supreme Court or the Constitution. And it says if it tries to do that, everything you do is null and void. The Constitution overrules the law of the land, and that's what I'm under.
In order to be heard by the Supreme Court, Mr. Durham, you have to first go through the district court. And
no, ma'am, that's not true. That's not true, ma'am.
Agree with it, then you can appeal it. But as of now,
I asked to see the lawyer's bond. I asked to see the attorney's bond. I asked to see the contract you have, so I can.
Do you want to retain your own counsel, Mr. Durham? He's muted. We'll just it just looks like that you're supposed to pay the fine of $50. So we'll just have you pay that on the next day by the next time you come back, which will be January 17th. So you need to pay the $50 by January 17th. At 8:35, which is your next court date. And then your jury trial date is February 7th at 1:35. All right, so you are all set, Mr. Durham.
Mr. Durham is saying something, but he's still muted.
Mr. Durham, you are muted, sir. I don't know if you know how to unmute yourself. It's the bottom left-hand corner.
I object to these proceedings.
Your objection is noted, Mr. Durham. So you got your jury trial date, and then you have your pre-trial date, the final pre-trial.
Okay, when is the prosecution going to send me all the evidence, including the witness, the damaged property, and the injured party's name? I need to know everybody involved. I need all this information.
Of course you do. Mr. Durham, what that is called discovery. And you have to do a request in writing for your discovery.
Ma'am, I'm not part of your society. I don't have to follow those rules and regulations because you can't tell me where to find the rules and regulations for statutory jurisdiction. Where can I find a copy of the rules and procedures for statutory jurisdiction? Because that's what you're operating under, statutory law, right? A statutory jurisdiction. Where can I find?
Here comes the jury of my peers' misunderstanding. He tries to redefine it as people who share his beliefs. But legally, it means impartial citizens, not ideological allies. You don't get to handpick a supportive audience. That's not justice. That's bias. This moment shows how selectively he interprets concepts, taking real terms and reshaping them to fit his narrative. But courts don't bend definitions to personal preference, and that's where his argument falls apart again.
Able to give you the police reports or whatever she has, she can email it to you so that you can prepare for trial.
Are you going to give me your oath of office and bonding information? That's including the name, address, and policy number of your bond?
No,
are you going to give me that?
I don't even know what all of that is.
Your public officials surety bond, just in case you violate my rights. All public officials must be bonded. You don't know what a bond is?
No, I don't.
I'm gonna write the treasurer, and they're gonna tell me the name of your bonding company. I'm gonna write the treasurer
myself. So I'm giving.
So you're not bonded. So you're not bonded, is what you're saying.
I've given you all the information that you need.
Okay.
In this hearing, so you are all set, Mr. Durham. Unless you had other questions, you are all set, sir.
Yeah, I do have questions, but you won't answer them. You won't answer none of my questions. Are you operating under a statutory jurisdiction, a common law jurisdiction, or admiralty jurisdiction?
This matter is concluded, so you're all set.
Oh, so okay, I understand now. The bully tactic. Don't nobody want to answer questions, but they want me to comply with. I don't understand that. How am I supposed to have compelled performance if y'all don't want to answer no question?
The judge offers a practical question, attorney or self-representation. Instead of answering, he loops back into demands and accusations. It's circular reasoning at its finest, never progressing, always repeating. Meanwhile, the court moves forward anyway, setting dates and expectations. This shows a key truth. Refusing to engage properly doesn't stop the system. It just leaves you behind while it proceeds without you.